Thank you, everybody that's joining for today's CLE. We're going to get started in just a couple seconds, but thank you again. All right, looking at the attendee list, I think we've reached a quorum. So first, thank you all for joining us for Penning Precision today, where our speakers are going to give you the tools that you need to hone, sharpen, and shape your legal writing so as to best serve your client's interests. My name is Stephen Hushka, and I'll be moderating the panel today. I'm a shareholder at Kessler & Collins PC, where my practice focuses on complex commercial litigation. And this is a program that I am unbelievably excited and honored to be associated with. Day in and day out, legal writing is one of the most important arrows in any attorney's quiver. And this is true whether or not you're a litigator like myself and Chad Baruch, or a transactional attorney like Kevin Vela. That said, the best way to effectively use legal writing to achieve our clients' goals can differ drastically on a case-by-case or a deal-by-deal basis. And that's why the Dallas Association of Young Lawyers is ecstatic to present this CLE, offering perspectives from both a powerhouse litigator and a powerhouse transactional attorney on how to refine and adapt your legal writing. Starting with Chad Baruch. Chad is the managing shareholder at Johnson Tobey in Dallas, and he frequently lectures on legal writing. Chad is perhaps best known as the author of the hip hop brief before the U.S. Supreme Court, in which he represented Killer Mike, T.I., and Big Boy. He's a former NCAA basketball coach and the only Jewish lawyer in Texas history to serve as president or chair of the State Bar of Texas. Turning to Kevin Vela, Kevin is the managing partner of Vela Wood, where his practice focuses on venture financing, mergers and acquisitions, fund representation, and gaming law. Kevin brings excellence to legal writing in the transactional space, but he is also a well-known and highly sought-after mentor to many lawyers and students, in addition to teaching 2 separate venture law courses at SMU Dedman School of Law. Thank you both for joining us today for what's going to be a fantastic panel. So let's start with a big picture question. The framing or presentation of arguments and deal points is an incredibly important part of all of our practices, transactional or litigation. Broadly speaking, what key considerations do you keep in mind when advancing your client's goals? Let's turn
to you want to go first?
Yeah, go ahead, Kevin.
Okay, sure, I'll go first. You know, when I was in law school, there's obviously a huge emphasis on legal writing, but most of it's constructing arguments that you're going to prepare for briefs or for court situations. For transactional lawyers, the guidance is a little bit less. There are contract drafting courses, and I took one in school, but that was just one course. There was never any real follow-up, and it's not like building persuasive arguments that really flow into most first-year courses, and a lot of later courses are required bar courses. So for the transactional side of things, it's very different, but I do think it's important to pay close attention to your legal drafting strategy. One easy one that I'll start with is know your purpose. I know Chad's going to talk a lot about knowing your audience, and that's something that litigation attorneys use. But for transactional drafting is to know your purpose. The easy example is, who are you representing and who's on the other side? I'm a venture attorney, so we represent a lot of startups. And when I'm drafting documents, I want to draft them to be favorable for the startups. I want to earn points for the startups. From time to time, we might represent investors. And if I'm leading the drafting in those situations, representing investors, the documents could be a little different. Same when M&A transactions are talking about buyers and sellers. So I will start broadly on the transactional side is, what is your purpose? Who are you trying to represent and what points are you trying to make?
Kevin, let me ask you, do you, I would suspect you also have some contracts you draft where you have a technical client, but I suppose there are probably instances where you're sort of representing the deal too.
From time to time that happens, especially with smaller transactions where two parties might come and say, we have agreed to these terms. We just want to memorialize them. Can you help us there? And as you get further into drafting, especially if you become a commercial contract specialist, you start to understand that, I don't know, 50, 60, 70% of contracts are the same, right? They're all going to have a preamble or an opening. They're all going to have what people like to call recitals. I call them background. They're all going to have miscellaneous at the end. And then usually somewhere in there, you're going to have to discuss indemnification, limitation of liability, obligations of the parties. Once you understand that, then it becomes very easy to draft them in favor of a party, favor of party A, favor of party B, or down the middle. And there's just variations that you can use in the language. So yes, Chad, that definitely comes in. It took me, as a young lawyer, it took me a long time to really understand that nuance or difference. So I'm glad there's so many people here listening in. For those of you that are on the transactional side of things, know that start with, what is my purpose, right? Am I drafting for this party? Am I drafting for this party? Or am I drafting down the middle? And that will inform the language that you use for different sections.
And that's a great point. And Chad, I know you're going to talk a little bit more about knowing your audience, but on the litigation side, there's a lot of parallels as well. You know, knowing your purpose, the decision, the purpose, in my experience, though, is much more long-term. You know, your purpose is to win the case, and how do you shape your arguments on a motion by motion basis? And it's kind of the same thing of looking at the deal holistically. You have to look at a case holistically. But Chad, what about you? Let's talk about some of the key considerations you keep in mind in
Sure.
advancing your client's goals.
And to make clear, 90% of my writing is at the appellate court level. I do very little trial court work. So I should probably make that clear at the outset. Some, but the bulk of it is in the Court of Appeals. So, I revert to sort of knowing your audience horizontally and knowing your audience vertically. Years ago, I was working on a First Amendment case with Tom Phillips, the former, at that time was the immediate past Chief Justice of Texas. And we were working on it. He joined the case in the Supreme Court. I had handled it in the Amarillo Court of Appeals. And the first call we had, he had read my brief and he said, "You wrote a great law review article for the Seventh Court of Appeals." And he definitely did not mean it as a compliment. And so I think that's an important thing. Really, one of the best early lessons I learned about legal writing was from Randy Roach, phenomenal appellate lawyer in Houston, who had a presentation back in those days that he entitled I think it was called Reader-Centered Writing or something like that. And his point was, you begin with your overarching purpose is to write for the reader, not for yourself. Most of us as lawyers have a particular style we like. If we were on law review in law school, that's the first serious legal writing we ever did. So that's what we knew, and that's what we were good at. And we knew the blue book better than everybody else, and that's what we like, right? And we get very snooty and look down our noses at everybody who doesn't do it that way. Other people, I had a couple of friends who right out in law school went to work for smaller personal injury firms. That's a different style. But we should be thinking about the reader. So you don't write for the Dallas Court of Appeals the same way you write for the Texas Supreme Court. That's very different. And you don't necessarily write for the Texas Supreme Court the same way you would write for the United States Supreme Court. Very different. So I think knowing your audience sort of in terms of the vertical levels of the judiciary is very important. And then there's sort of a horizontal element as well. Know each court that you're in. So for example, there are vast differences. So the Texas Supreme Court, anytime you listen to any of those folks talk about writing, they will tell you they want a good narrative and they prefer names, right? They want to call the parties by their names. Don't call them petitioner and respondent. Well, I've got a case right now, just filed a brief in the Oklahoma Supreme Court. They don't just prefer it, they require it, that you use the party designations, and they get really cranky when you don't. You go to their CLEs and it's all about party designation, party designation, party designation. So I think, knowing the court you're in, do you write the same way for, Judge Redmond that you would write for Judge Moye? Maybe, maybe not, but I think it's important to make some inquiries about that. Do you write for a first-year judge, for example? We have some very, very new young judges on the trial benches in Dallas. Would I maybe craft something a little differently for them than I might craft it for Judge Moye, who's been on the court, for so long? Yeah, I can. Some cases probably not, but in some cases, yes, probably. So all of those things I think are really important. But the core lesson is to put yourself in the shoes of the reader. Think about what it is you want the reader to do and what's the best way to get them to that point.
But, and I think that's invaluable advice in terms of doing a little bit of field research and finding out who you're writing for and tailoring your writing to that individual. And that's particularly important in our role as counselors in private practice, because clients hire us to be effective legal writers, not necessarily good legal writers. And so I understand it could be different from courtroom to courtroom or deal to deal, but generally speaking, are there some tools that you use across the board to try and shape your writing or your negotiations to achieve the goal of being an effective legal writer? And Chad, you just finished up, so why don't we start off with you?
With me? Oh, okay, sure. Yes, you know, you have to take, let me just follow up to what we just talked about. I think you have to take some care in how far you go. You know, as actors, my dad was a theater professor, and actors say you don't want your technique to show. To some degree, there's a little bit of that in legal writing. You can obviously go overboard in tailoring to a specific judge. But I think it is well worth the effort to understand how a particular court or a particular judge may view things. When I talk about effective legal writing, there are three things that I am particularly interested in. And I'm not saying these are the three best things by any stretch. I'm just saying they're the things that have caught my attention over the years. One for sure is sentence structure and length. So, you know, readability is so important. And some people, you read their writing and it's not technically poor, it's competent writing, but you have to read it 3 times to understand what they're saying. And then other people, you just read it and it's like an easy read through. One of my favorite all-time writers was a guy named Robert B. Parker, who wrote the Spencer mystery novels, if anyone's old enough to remember Spencer for Hire from television. He was just a phenomenal writer. He'd been a professor of English at Northeastern before he started writing those books. And he was the master of varied structure and length. What makes writing readable and easy to comprehend is varied sentence structure and length. So Parker, for example, you would never see him, almost never see him, use 2 consecutive sentences of identical length and structure. You might have, with him, you might have a medium length sentence, just a period. Then you'd have a much longer sentence with a comma or 2. Then you'd have a 3-word sentence, so on and so forth. A legal writer who does that is one of my old high school debate rivals from Wisconsin, Paul Clement. Paul, I think, is, you know, universally acknowledged as the leading appellate lawyer on the planet, and he does that quite often. If I know we're going to talk about resources, and I'll mention this more then, but if you look at the brief Paul filed in the Affordable Care Act case, the Obamacare case in the U.S. Supreme Court, that's sort of universally acclaimed in the appellate community as one of the really best briefs filed in the Supreme Court in the last decade or two. And one of the things he did in there multiple times, you will see him use a very, very long sentence followed by a 2-word or a 3-word sentence. So, for example, I know there's one in there where he has a very long sentence and then he just says, and so on, period. Or he might, you know, summarize the other person's position with a lengthy sentence and then he would say, but that's wrong, period. That sort. So mixing up structure and length, I think that's number one. Second of the 3 would be verb choice, although I might widen that to say word choice, but definitely verb choice. Verbs are the most important because they drive the narrative, right? They're the action words. They literally are the words that move you forward. So I used to tell, when I was teaching, I would tell my students, if you choose dull verbs, you get dull writing, period, full stop. If you choose vibrant verbs, you're probably going to get vibrant writing. So I use what I call the rule of 3. The be verbs are the worst, right? Is, any variation of is as dull a verb as you can get. And if you have 3 or more of those on a page, you're probably going to have dull writing. So pay some attention, look at the page and see. If you see is more than a couple times, I would go through and take them out and recraft the sentences to use more interesting and dynamic and working verbs. And this is something really good writers sometimes struggle with. About 15 years ago, one of the Supreme Court justices in Austin actually asked me if I would critique opinions for them. They sent me like 15 opinions. Would you just give us a writing critique? And one of the things I noticed was, as you can imagine, you don't get to the Supreme Court by being a bad writer, but there were a lot of is sentences. I mean, almost all of them. I would say 75% of them were using is, and just get a little more interesting verb. So one of my favorite examples is actually from Carly Simon, of all people. I think Carly Simon is a phenomenal writer, and not surprising, I guess, that the heir to the Simon and Schuster fortune would be literate. But think about her classic song, "You're So Vain," right? There's a lyric in there. He had one eye in the mirror as he watched. You had one eye in the mirror as you watched yourself. And you ask people, I've done this at CLEs over the years, no one's ever gotten it right. I say, what's the end of the lyric? And they all say, go by, as you watched yourself go by. It's gravat. It's a French word that means to prance and preen for yourself. As you watched yourself gravat. Like, what an interesting, dynamic, sort of out of the middle of the road verb to use that dressed that lyric up. So that's number 2 is verb choice. And then number 3 only applies to 20% of you out there. But if it does apply to you, you know it because every teacher you had since the 5th grade told you, and that's the use of the active voice, right? Really, really avoid the passive voice. If you can go from passive to active, 2 things happen. You get a shorter sentence, you get a more powerful sentence. The only time I think you want to use the passive voice is if you're representing the bad person and you want to take all of the energy out of the sentence. But other than that, work really, really hard on the active voice. So those are sort of my 3 big picture items: sentence structure and length, verb and word choice, and active voice.
And those are all fantastic tips and all things that my judge, when I was clerking, really hit on too. So these are things that the judiciary definitely cares about, thinks about, and looks at when they're making decisions. But on the transactional side, based on my limited understanding, Kevin, it's not so much the burden of persuasion or convincing a third party that you're right, but the burden of negotiation, getting the best deal, hitting the deal points or overcoming objections to deal points your client cares about. So how do you go about crafting your legal writing or your practices to be an effective legal writer?
First of all, I got to finish taking notes. I'm taking notes on what Chad is saying, and this is fantastic. And I appreciate that, Chad. So you started by asking what tools do you use? I subscribe to Brian Garner's newsletters, right? Law Pros and his usage of the day, and everyone should do that. Right in your inbox. Here's a thought. Here's a couple points. I subscribe to Grammarly's newsletters, and I use the free Grammarly plugin on top of my browser, which is fantastic. And so it helps with, a lot of communications these days. We use Slack pretty heavily for interoffice communications, and I might type things into there. If I have Word, you can put a Grammarly extension into Word. That helps. It's just a better editor than the Microsoft Office products. And you can do a paid version, which is now using AI to kind of get used to your writing. And then there's a book that we talked about earlier, Stephen, called Typography for Lawyers, which I recommend. It's an easy one to pick up, and it's got just good stuff about formatting and visual representation and white space and stuff like that. So I highly recommend that to everyone. I just had a thought, Chad, that we hadn't discussed earlier is transactional lawyers, because you redline documents, there's a lot of lawyers grading other lawyers' papers in these situations. I don't think this exists in the litigation world. I don't know, but it's not uncommon for me to send a document out and then come back from another lawyer with a bunch of red lines on it, right? And the way that they want it drafted or points. I do not get real fussy about people changing the way I'm writing something as long as it gets to the right point. I see my job as a corporate lawyer to get the deal done, not to win the drafting battle. And some lawyers like to do that. They love to dump red and rewrite your sentences as long as it still has the same contractual obligations or enforcements or rights. I do not get frustrated by that at all. I see that as not a good use of clients' time and money. That's not my client. But that's a good one for young lawyers because I have young lawyers here who get really frustrated when we send documents out and then they come back and they're completely rewritten. A lot of times we're a boutique. A lot of times we send them to big firms. The big firms, they have a way they like to see things done that's kind of institutionalized, and they will rewrite, reorder things to their way. I tell my attorneys, we don't have a budget to go change that. So if it hasn't changed the legal meaning or if it hasn't impaired our clients' rights in any way, then just keep it. It's totally fine. So that's just one thing for young lawyers to look out for is on the transactional side is there's going to be red lines. But that's interesting. When other attorneys make comments that are good and they say something more succinctly, or they rewrite the point for clarification, or they add an example, I will put a footnote back in the document that says, thank you. I appreciate that. That was good. That is very much a tact in negotiating. Because when you're on the corporate side of things and you're trying to win these points, there's a very good chance that the clients either don't know that this is going on or they don't understand it. They're not going to understand. We had an hour-long call this morning with a client about indemnification, about very complex indemnification, limitation of liability clauses. And the client he may as well have been sleeping during it. So he's not going to care. So, but I need to convince the other party that, hey, the way I want to do this indemnification procedure, that we need to win these points. And this isn't so much about drafting, because we're not arguing over what is. We're trying to get points. We want to do this our way. They want to do it their way. Well, if I can compliment the attorney in a previous turn and say, man, I really appreciated those red lines you made. We're going to accept those. Or this is why I tell my attorneys, just accept the red lines that aren't going to hurt us. Just accept them. I can build rapport with that other attorney. Say, hey, look, we gave in on these points, or I appreciate it. I'm going to take your points on that. This point's very important to me because can you give in on this? But from a transactional side, it's really important that you learn how to go out and get points. I'm saying points, but to get the clauses or the side or the angle that you want within the certain provisions. I have a way of doing it. My way of doing it, which I try to push down to the firm, is to be accommodating on points that we can be accommodating on. I will be overly accommodating to a point I don't care about. Sure, whatever you want to do, you rewrite the whole thing. You think that looks nice, fine with me. But the points that we really care about that are very important to our client that we're not earning or we're having a hard time getting, those are the ones you really got to save your political capital, your negotiation capital. So, Stephen, the way I approach it is I try to signal things. One is I will compliment them, the other attorney. Guys, everyone loves it when their drafting is complimented. We're all lawyers, right? Everyone loves it. So when that's appropriate, I will do that. I also signal, and I'm curious to hear if Chad does this as they're swapping briefs back and forth. I will also signal ahead of time, hey, we're going to change a few things here. Rather than just sending back a document that's just redlined to the bejesus. Because typically what happens is you tell your client says, when is that document going out? I say, I promise it's going out on Friday. And then that means Friday at 5:30 p.m., right? When I'm running out the door trying to get to dinner, the last thing I do is I send it out to tell the client, hey, I told you Friday I got it out. Well, now the other attorney on the other side, if you're on a deal and they're trying to keep the deal going, 100% they're going to check their phone as they're waiting for dinner. And then they're going to see the document and they just see it littered with red. They're going to get all fired up. They might respond back to you on Friday night, which you do not want. You do not want to motivate them to go Saturday morning when they're probably clean and fresh and don't have a lot of distractions and dive into your agreement. So I try to disarm them by saying, just signaling, I couldn't get the client aligned on that indemnification point. I've made some suggestions here. I'd really appreciate if you take a look at it on Monday morning. Let me know what you think. And it's just like an easier way of easing into the negotiations. And we've had pretty good luck with that. I've had good fortune with that. Ultimately, the best way to win the points is to understand them very, very deeply and understand the arguments and be able to build and construct those arguments, right? Those legal rational arguments. Those are really where logic games come into play from the LSAT. A lot of those constructions are the same. But if you don't have good facts or circumstances on your side, and you need to come up with other ways to try and get these points, those are a couple of ways to do it.
Well, and I love all those points as a litigator as well, because especially your point about accepting the red lines, because that on the litigation side comes into play a lot, because clients pay us to be effective. And if we have a disagreement on 5 points, but really we can reach an agreement on 4 of them, we're going to be much more effective litigators if we file a motion that can pinpoint what's really at issue for the judge. And the judge is going to be happy about that, but we're going to be able to explain that in the time that we're given, the limited time at a hearing, more effectively. And it's just better for everyone. So focusing on the issue at hand and really only fighting about the things that matter, I think that's beneficial to both litigators and transactional attorneys. So I think that's an excellent point, Kevin. So we've been talking kind of broadly about big strategies that we use for effective legal writing. But in my experience, a lot of times what wins the day are the little things. It's a game of inches, maybe not necessarily feet. And so what's one small consideration that affects legal writing that you guys feel like is frequently overlooked in your practice? Let's we started with Kevin last time, or we started with Chad last time. Kevin, why don't you go?
Sure. I think there's a real easy one on the transactional side that's frequently overlooked, and it's formatting. It's formatting. That's why that typography for lawyers is so important. At my firm, we have a firm standard on drafting on font, page layout, footers. They all look the exact same. There's a couple of benefits there. One, I know if a document came out of my firm or not. Two, if there's multiple documents, it can get distracting. You know, the legal complexity, the language is complicated enough. I don't want to be distracted by, why does this one say page 1 of 6 and this one just says 1 of 6, or this one just says page 1? Like, why aren't those things lined up? You know, and why do I need to spend time asking my paralegals to conform these? Those things are just distractions, right? Our jobs are hard enough, they're complicated enough, so everything comes out looking the same. Why is font different? You know, why is the font, if I'm sending 3 agreements to a client, why are the fonts different? The client's going to say, did you not produce all of these? Oh, you just grabbed this from a form from someone else, right? This is a different deal, and you just grabbed a form, and are you going to charge me for this? You know, clients love to say, just pull a template, pull a boilerplate template off the shelf, right? That's easy, right? Just do that real efficiently and inexpensively. So formatting, so we take great pride and care here. We deal a lot, I'm a venture attorney, so I deal a lot with venture documents. There's a standard set of documents called the NVCA. Anyone here who does venture work, they'll know. NVCA, National Venture Capital Association. They promulgate their own forms. Times New Roman 12, they all look the same. We don't change those a bit. I want other attorneys to know that if we have agreed to use the NVCA standard set of docs, that I'm not trying to lay a trap somewhere and changing things. I just want the document to look as much as possible like the documents that they're used to, so we can just focus on the substantive points. So an easy one that's often overlooked, Stephen, I think, is formatting. And for anyone who's listening in, who's got a small firm or works at a boutique, then I would encourage you to standardize your formatting across the firm. It just looks better. We use Cambria 11 for all contracts other than ones that we don't control, like NVC, are coming in from the other party, and we use Garamond 12 for all letters. That's it. It's just very easy, so I always know what comes out of us. So that would be my guidance.
And that's a great point. And Chad, I think you're going to talk about similar points on the litigation side, but I just want to say the book that Kevin was talking about is a book that I have in my library, Kevin has, and Chad does as well. I'm holding it up. It's Typography for Lawyers. It's by Matthew Butterick, and it's excellent. It's a suggestion for how your writing can be more legible and more persuasive. And so I'd recommend it that all of you look at adding it to your collection. But Chad, what is kind of a small thing that you feel like is overlooked for persuasive legal writing?
I'll actually give you a couple. I'll sort of piggyback on what Kevin said, which is the really critical importance of formatting in both trial court and appellate court briefing. That's number one. I think that's really, really important for both sort of two different reasons. Number one, you want it to be good, and judges do notice when it's good. I will tell you that. As I told you guys when we were getting ready for this, I had a judge just make a comment to me a couple of weeks ago about how much he appreciated my formatting in my briefs. And more importantly, you don't want it to be bad. And sometimes you get things filed. You don't want to be the humor slide in a Supreme Court justice's PowerPoint on legal writing. And that happens. You know, they get things where they use in their presentations as examples of just horrifying formatting. Weird fonts or changing fonts halfway through the document, or bizarre formatting, or whatever the case may be. So I think you want good, clean, simple looking documents. Nothing fancy. I don't use a lot of font features. Everything I'm going for is just simplicity, simplicity, simplicity. That would be one. The other would probably be introductions. I mean, I just think in the persuasive writing context, at least, introductions are really, really, really important. And by the way, I think this, happens in transactional writing too, to some degree. When you talk about background, or what some people call recitals, I think background makes a whole lot more sense to me, but that's sort of an introduction, right? Because to me, an introduction is context. That's what it is. give the reader, it's hard to just jump in. So in the transactional world, I would think it would be hard to just sort of jump into the deal terms without any sort of context as to what you're talking about. On the appellate side, it's very hard just to give an issue with no context. So the introduction just gives the reader that little bit, I mean, ideally it's persuasive as well, but it's sort of persuasive through context. So I think that's really important. And another one, so a corollary I will give you in the trial court is often overlooked. Surprisingly, one of the most common or frequent comments I get from trial judges is they'll say, you have no idea how many motions I get where I don't know what I'm being asked to do. I read the whole motion and I can't figure out precisely what. So one thing I've encouraged my partners to do in our trial court motions is all of our motions begin the same way. It has a title, number one. It has nothing underneath the title. I emphasize that only because I'm not a big fan of comes now so-and-so, right? I hate that. Like, who comes, if you go home every night and say, comes now your spouse for dinner, then go ahead. But otherwise, I would get rid of it. And I never understand the logic of repeating the title of the pleading in the first sentence of the pleading, right? I mean, you've just said it's plaintiff's motion to compel, and now you say plaintiff files this motion to compel and respectfully. So no, we have a title, we have an introduction, and in the trial court, our very next section is titled Relief Requested. And in one sentence, we're going to tell the trial court in the plainest English possible, here is the order we want from you. So that might be something people wouldn't think about. Just a little tip for trial court persuasion is tell the court right up front, give them the context in the introduction, and then tell them in plain language, here's what we need you to do.
I want to make a point about the recitals or background. I call it background. I think Brian Garner said to do that one time. Recitals you're just setting people up like, hey, I'm some old, lawyer writing in the 1600s. Like, let's just call it like the whole whereas stuff. I just call it background and number them. But from a contract perspective, think about background as the meeting of the minds, right? Like Chad said, let's set it up. Let's make sure we're talking about the same deal. Let's make sure we're talking about the same underlying documents or whatever the premise is of this particular agreement. So I use the background to establish the meeting of the minds. Typically, recitals or background are not contractual in nature. If you're going to incorporate them into the contract, you need to do that by reference. But you can use it just to make sure we're all, like Chad said, thinking about the same thing.
Mm-hmm. And in that regard, it kind of, if you start with the recitals, it can kind of give you a skeleton or outline for the rest of the contract. Sometimes it seems like it would, which leads me to the next thing I want to talk about. A lot of times when you have very complicated motions or complicated issues that you're trying to describe in a motion or complex deals, it can be a little bit overwhelming to start. And so can you talk to me a little bit about what your drafting process is and how you tackle those really complex deals or very complex briefs? Kevin, you kind of already started. Do you want to jump in?
Sure. That's one that's even harder for younger attorneys because you just haven't seen a lot. When I was a younger attorney, every contract seemed like a new one. And I didn't know where to start. Typically, if you want to start with a template or a form, and practical law has a lot of things covered, whether it's a different type of licensing agreement, they have software as a service, platform as a service, buyers friendly, supplier friendly, different types of M&A agreements. They have long form, short form, pro buyer, pro seller, different types of referral agreements, advisor agreements, independent contractor agreements. So a practical law is a great place to start, or at some point in time, you get to be experienced enough or just old, then you have a lot of, you have experience drafting personally. So you have your own template, your own forms library, right? Either that you have personally or hopefully that you share within the firm, and hopefully the whole firm is working off the same one. So you're using the same formatting like we discussed earlier. So typically, Stephen, it's rare at this point in time in my career that I'm ever drafting anything from scratch. Rare. But when I was a younger attorney, I remember doing it and it was so overwhelming to me. I just hated the process. I started with a blank piece of paper is so hard. Early in my career, I learned that if I got that blank piece of paper and I put my footers and I put my title and I went to my miscellaneous, so I don't have to use this anymore because I have all my templates now, but I used to keep a miscellaneous sections document that had all the miscellaneous sections you might want: severability, choice of law, waiver of jury trial, amendments, waiver, all those things. And I just put them in alphabetical order. I don't understand why people don't put these things in alphabetical order. It drives me nuts. Put them in alphabetical order. I would take that, I'd put it onto the contract, and that'd take a page or two. And then I had my top, and then I would just lay out the sections I need: obligations of party A, obligations of party B, representations, warranties, whatever. And then I was ready to, you can always do the preamble. This XYZ agreement is between these parties, between for two parties, among for three or more parties, right? Let's keep that in. There's a law pros tip for you. But then I would, drafting the recitals, like you were just talking about, Chad, the background, that's where you really got to think through, like, what am I doing? And that would probably take the longest. But anyway, the point being, once I got that document in, I put the miscellaneous, I put my footers, I put the top, I felt like I was 50% done. And a lot of times I'd stop that, and that was enough effort, and then I'd go and check my email, and then come back, and now I was ready to dive into drafting the contract. So I remember as a, I don't know, fourth or fifth year attorney, and I've got a boutique, so I had a younger attorney than me. I was explaining this to him, like, this is how I do it. That was a real aha moment for me, because breaking the drafting process up into setting up the document and then drafting it. And setting up was what all the angst came from. Drafting was actually kind of exciting. Right? You want to draft. I'm going to make my points. I'm going to make it look really good. I'm going to have this active writing. I like what Chad said about, dull verbs or boring verbs. I'm going to do this. I'm going to do this in my background. But setting up was such a pain in the rear. I just hated doing it. So once I got to that point, I broke those up. It all became much more straightforward.
Absolutely. And that was one of the things that when I was clerking, if I had a really complicated opinion that I was helping out on, it sometimes it was daunting because you have so many arguments and so many facts, and the record was so voluminous. And to your point, if you can just start typing and you can fill in the stuff that you need, and then take a step back and then really focus on the meat of it in separate sections, sometimes just getting it on the page makes it much less daunting in my experience. Chad, what about you? I mean, tell us a little bit about your drafting process, excuse me.
It reminds me of the cocktail napkin. There's a cocktail napkin or something that says, "My style of housekeeping can best be described as there must have been a hurricane." Mine is not what I would call orderly necessarily. And I've never been a big outline person. And a lot depends in my area, which side I'm on, right? There's a huge difference between drafting the first brief in the case, or being the appellee or the respondent, and drafting the second, responding to someone else's brief. Those are very, very different in terms of process to me. I guess if I were making general observations, here are a few I would make. By far the most important thing to any young lawyer out there is do what works for you. I mean, be open to listening to people like us and maybe the way we've done it, but do what works best for you. For me, most of the time that means drafting a clear and as complete as I can make it statement of facts up front. For whatever reason, I do better if I have the what happened. So remember, I come into cases oftentimes after they've been in litigation for 3 or 4 years, and everybody knows everything about the case, and I'm coming in totally cold. I don't know one thing. And half of what a trial lawyer will tell you is wrong. I mean, it may be true, but it's wrong in terms of the transcript, right? Because once that trial happens, what really happened goes out the window, and the only things that happened are whatever the evidence at trial said happened. And so you're going into that transcript cold. So for me, I find getting the statement of facts is the most important thing, first thing for me to do. Now, I will tell you, I know great lawyers who do it exactly opposite. So Allison Ho, one of the best appellate lawyers in the country, has told me, we were talking about this and she started laughing and she said, "I'm exactly the opposite of you. I do the facts last. I go for the law first." I'm like, well, that's because you went to the University of Chicago and you're smarter than me. But I just pinned down the facts. The second thing I will tell you, Kevin and I are similar, I think, in this. All my life, severe ADD type issues. And so if I can break a large task down into discrete tasks that I can check off my list, I'm a list maker and a list checker offer in all aspects of my life, right? And so rather than outlines, usually what I'll do as I read the brief, I'll read the briefs and then I'll sit down and sort of make a list of everything I have to cover. Not an outline, but just a free form list. One line, one line, one line. And then I'll start thinking about the order in which I think those things ought to come, whether it's issues or arguments within an issue. And then I'll start breaking it down like, okay, this morning I can get this one thing done. I can get a draft of that done. And then I can feel good about myself and take a break and do whatever, get on the Peloton, whatever it may be, come back and do the second one. That's sort of how I try to approach it, is break it down into kind of discrete things I can feel some accomplishment about, because otherwise it's just too overwhelming to me. You know, when you sit down with somebody's 60-page brief on the merits, it's like, ugh, I quit, I'm going back to basketball.
You know, I want to make a point about what Chad says is just find something that works for you. I don't think, you know, drafting, I think there's tips that hopefully people can take, and subscribing to these newsletters or the points I make about trying to be accommodating when possible on transactional drafting. Hopefully they can take that, but some of these things, you know, whatever works for you, it'd be best just find something. When I was a young attorney, I was always worried that, is there a better way of doing it? What am I missing? You know, I've got a boutique here. I started this thing right out of law school, so I didn't have any attorneys tell me what to do or coaching me up. So I was always so overwhelmed by what I didn't know. Right? This is probably a terrible way to draft a contract. There's got to be a better way of doing it. It took 4, 5, 6 years to just get comfortable with my own style. So hopefully we can encourage some young attorneys here to just do that sooner. You're going to have your own style. Be confident in it. If it's working and you feel like you're progressing on your career, then it's great. Then just own that and don't worry about the way someone else might do it.
Absolutely. I think that's wonderful advice for the senior attorneys here, but also a lot of the young attorneys that are here. And turning to that, a lot of the things we've been talking about can be used by attorneys of all ages, I think, but specifically for the younger, more novice legal writers that are just trying to jumpstart their practice. What advice do you offer to them? And Kevin, you just opened the door to that, so why don't you start?
Sure. So a couple of things. There's a lot of great resources out there. If you're a young attorney or a first year, you're here, congratulations. That's awesome. You're doing the right things. These are great ways to get information. The only reason why I know more about this stuff than you do is because I'm older. Like, so much of practicing law is experience, right? You guys know that for sure. So you're on the right track that you're here. There's great resources out there. These books or these newsletters that we're recommending, I think if you just get into those for 6 months and you read them, you'll pretty quickly pick up some things. And then you'll know that you could just spend 5 minutes reading that newsletter once a week and either add to your repertoire, or for whatever reason, that tip isn't practical or useful for you, and move on from it. And that helps to eliminate this fear of the unknown that I used to have. Like, what else is out there? So the first one is use the resources available to you. And then the second one is just reach out to a mentor, whether it's in your firm. If you don't have one in your firm, through your law school network. If you don't have a law school network, through the Dallas Bar, just reach out to someone. There's a lot of things that I'm sure if you want to get into appellate law, that Chad could answer for you in a 5-minute conversation or just a quick response to an email. And I don't want everyone flooding Chad with appellate requests. He's a pretty busy guy, but I just want you guys to know that as you get more experience in these, you understand these answers to these, you know, kind of global legal practice questions, they're typically can seem for a young lawyer like, oh my gosh, how do I figure out how to do this? And an experienced lawyer can answer it very quickly. So, you know, find a mentor, find someone, hey, do you mind if I email you every couple of weeks with a quick question? Everyone loves to be a mentor. I certainly have people that I'm very thankful for. They're very helpful when I was a young attorney. And so I consider answering questions of young attorneys a way to pay it forward for those people that were so influential and instrumental for me.
Yeah, and mentorship is so important in this profession. And so to the extent you have an opportunity to learn from someone who is as skilled as Kevin or Chad are, take advantage of that. Chad, I think you're probably going to echo a lot of those sentiments, but what's some advice that you have for more novice legal writers on how they can jumpstart their practice?
Well, I can think of a few. Number one, I think, and I know this sounds ridiculous to say, read. Voracious readers almost invariably become good writers, and good writers almost invariably are or were voracious readers. And that's an ongoing process for me. So, you know, I probably had no choice in that both of my parents were university professors. My dad was a pretty well-known scholar of Greek and Shakespearean tragedy. Give it up for Greek tragedy. I hate that stuff. And my mom was an English literature person who had a lifelong obsession with Ulysses. So, you know, there was going to be brain damage no matter what I did. But I find even as I continue to read, so like 20 years ago, or so, maybe 15, 20 years ago, when Ron Chernow's book on Hamilton came out, the basis for the musical, that, you know, 600-page biography, that was a book that really affected my writing, because that was probably the book that really got me focused on word and verb choice. Because as I read the book, I just kept thinking, wow, does he use some interesting verbs and some interesting words? And it kind of got me started. In fact, it did get me started on keeping what I called my word journal, right? And I started writing down words from the book. And then I started writing down interesting words from other sources. And pretty soon I had this little spiral notebook of words that my children mocked me relentlessly for. Oh, there's dad in his, you know, word journal, right? What a geek. Until one night I was watching 60 Minutes and they were interviewing Eminem. And, you know, pretty cool, right? Eminem. And he pulled out a box of spiral notebooks that were his word journals. And, you know, immediately I'm all children to the parental bedroom, all children, right? So read. I think reading can, same thing with Team of Rivals. I just thought, wow, the narrative storytelling there. And sometimes you read and it's bad. I read a biography of Mickey Mantle a few years ago that I was very excited to read, except that the author kept doing like jump back and forth in the narrative, end of career, beginning of career. And it was so confusing to me. I thought, I will make sure henceforth, every brief I ever file in my life is going to tell the story in chronological order, because it's just too confusing. So that would be one, is read. Read other good writers and other good legal writers. I will give everyone a recommendation for some reading, or 3 or 4 recommendations. You all mentioned Typography for Lawyers, fabulous. Point Made by Ross Guberman, I think, fabulous. There it is. Yeah, absolutely fantastic. And what's fantastic about it is he does a lot of the work for you. He goes out and uses examples from the best appellate writers in the country. So that one's really good. I think Garner's The Winning Brief. I mean, you can pick any Garner book, but I love The Winning Brief. And one more I will give you that's a little off the beaten track, but I can't remember the case name, but it's very easy to find. Justice Kagan. Read almost anything by Justice Kagan. I could just say that and stop. I mean, they're all 9 of them are phenomenal writers, but I think everyone recognizes that she's sort of a generational writer. But she wrote a concurrence or a dissent, I forget which, with Justice Scalia about a decade ago. It was in a criminal case. It's very easy to find because it is, I'm certain, the only U.S. Supreme Court opinion to cite Dr. Seuss as legal authority. She cited one fish, two fish, red fish, blue fish. So you can always find it that way. But it is just a masterful piece of legal writing, start to finish. And it's one that I would really recommend young lawyers take a look at. I'm partial to it because just as I'm probably the only lawyer to ever cite Tupac in the U.S. Supreme Court, she's probably the only justice to cite Dr. Seuss. The other thing I would encourage younger lawyers to do is my son is in the television business, and as somebody told him years ago when he was wanting to be a filmmaker, he got really good advice from a very successful filmmaker who said, movie makers make movies. Good writers write. And if you can find ways to stretch your writing and do a little writing outside the legal writing arena, I think that helps. So every few years, I will try and do some historical writing. Last year, I published a piece on Curly Bill Brocious, very famous outlaw in the Old West, and a legal escapade he had in El Paso that ended up in the El Paso Court of Appeals. And I found it really useful because I went down there, did a fair amount of original research, and wrote that story. And I found it really helpful in terms of narrative work, you know, kind of honing my ability to tell a story, get the attention of the reader. Sometimes that can be hard to do with history writing, right? Or I have one of my former students who is a journalist. She's you may know her, Jory Epstein, very prominent sports journalist, covers the Dallas Cowboys. I like talking to her, their kind of work. They're so good at narrative storytelling using such limited space, right? They have to get it out there quickly and efficiently. And so those types of things, just read and write, I think that has an enormous, will have an enormous effect in terms of improving writing.
And I love that you brought that up, Chad, because we didn't talk about it in our preparation session, but about 5 years ago, I was reading an article where there was an interview with the current Supreme Court justice, and they asked, what recommendation do you have for improving legal writing? And that was exactly that: read good writing. And so, again, just more proof that these are things that judges are thinking about, and it's undoubtedly going to improve your practice. When you're looking at legal writing that was drafted by younger attorneys or associates, what are some common mistakes that you see, and some proposals that you have to try and avoid falling into those traps? Chad, we just heard from you. Kevin, what are you seeing in your practice?
So again, I'm not critiquing writing all that often. It might be, hey, there's a simpler way of doing this. Sometimes in transactional documents, you'll get into math calculations. And so I'd like to try and use examples for that. But I don't get to critique. Every once in a while, one of my attorneys will want to write a blog. We put a lot of content on our website. And so that's more one. And I do want to make a point, as a transactional attorney, from time to time, you will need to send a summary or guidance to your client on a long transaction. So long emails or sometimes a letter. We don't write letters all that often anymore, but if the client wants to be able to save it for file, or you want to be able to save it to file to show that this is the guidance I gave to the client, because they're not going to take your advice and you want a CYA on it. So a lot of times I'll put that in a letter. That is a time for legal writing. And I do enjoy that challenge, kind of like Chad said. I don't consider myself a great writer. But like Chad said, writers got to write. Because I am now not writing a contract and writing a letter to a client or to the board of directors that we do frequently, and trying to explain a legal situation and provide guidance. I like that challenge, right? Trying to kind of explain it like I'm 5 or put it in more layman's terms. But to answer your direct question, what is a common mistake you see? I see too many young attorneys. From time to time, I will see young attorneys who just dive into the contract and start drafting the contract without doing the background research first. Just, I'll say, hey, attorney, here's the set of facts. Please go draft this agreement. And I'm working quickly. I'm trying to sign 3 projects that day. I might not have looked carefully. Like, double check the email for me and make sure that that's the right agreement that we want to start with. So just do the background research, right? Like, know the underlying facts that are leading to why we need this agreement. I think a lot of attorneys like, oh my gosh, I just got this assignment from my partner. I better turn it around quickly. I'm just going to get in and start drafting. Where had they taken 5 to 10 minutes to just review the email history, look at the client file, ask a couple of questions, then they're just setting their mind on the right track for what am I actually trying to draft and accomplish here. And it might not be exactly what the partner asked for. I tell my young attorneys all the time, you have to learn to distinguish between what the client's asking for and what the client needs. Because the clients, they do not know what to ask for frequently. They'll call and say, I need a referral agreement. And they don't. They need a license agreement, right? And so if you just start drafting a referral agreement, you're going to get an hour into it, bring into the partner's going to say, I can't use this. Right? The email, I know the client put referral agreement in the subject, but if you read the email, the client clearly needs a licensing agreement. So the mistake I see is trying to get into the project too quickly without doing some background on it first.
That's a great point. That's a very good point. Chad, what about you?
Sure, I'll give you a few thoughts and then I'll try to sweep in the question we got there. By the way, let me just say, one of the hallmarks of a great writer is not thinking that you can write anything. I almost never file anything that I feel good about. I mean, it's just like, well, there goes another piece of garbage. I think that comes with the territory. You get very self-critical. In the litigation and appellate context, I would say some common mistakes would be, number one, combativeness, sort of, writing in too combative a tone, too harshly, too argumentative, calling the other side's argument stupid instead of simply demonstrating that it's stupid and letting the judge reach that conclusion for herself, that sort of thing. That's number one. Just being mean and combative. Number two would be too long. I think as you get older, you get a little more sense of what you can leave out. When you're younger, sometimes you're so afraid of leaving something out that you end up just making it too long. And the truth is, everything we write as lawyers is probably too long. Just shorten it up. The shorter, the better. A third would be lack of thematic development. So, you know, in the persuasive arena, every piece of writing should have a theme. And the reader should sort of be able to absorb the theme. And I see a lot of writing for younger lawyers that it may be technically good, but it doesn't sort of have any overarching theme or purpose to it. And when you look at the really good writers, you always see theme, and you see them, once they identify a good theme, they continue to pound at it. A couple of examples, again, to go back to Paul Clement's brief in the Obamacare case. Their theme there was boundless government power, boundless. And they used that word, they used boundless or without boundaries. They played with that phrase, I want to say something like 42 times in that brief. I mean, it was just this relentless pounding away at this notion of unbridled governmental power. We tried to do the same thing in the hip hop brief. You know, and another example I'll give you is, so the theme in that brief was that hip hop is not literal. The Fifth Circuit mistakenly interpreted a hip hop song as a literal threat. And we tried to pound at that every way we could through the brief, even on the first page where we have to identify the amici parties. You know, in our identification of Killer Mike, we said Michael Render, aka Killer Mike, is a Grammy award-winning, you know, artist and activist. But for this brief in particular, we should point out that he's never actually killed anyone. You know, just right from the get-go, here's the theme, right? It's not literal. So, and that should be probably the last thing you do. I write my introductions last. In any project, the introduction comes last because I'm really still thinking about all the arguments have to be in there before I really have a notion of what I think the theme is going to be. And so then when I craft the introduction, well, sometimes you have to go back and retool the arguments to continue pounding at the theme. We did have a question that I think fits in the vein here, which is, what do you do as a younger lawyer if you're listening to people like us, or you were taught this way in law school, and you're working for a much older lawyer who is still wedded to the 1978 style of brief writing or motion practice or whatever the case may be? I told you guys this. I always have the same answer, which is just wait for him to die. But you know, obviously, you have to do, in the interest of self-preservation. If you're working for a senior partner, then my advice is do what the senior partner wants. I mean, that's the person signing your paychecks. And I think that's what you have to do. I don't have any, I wish I had a better answer to that. But just as it drives me crazy to tell the Oklahoma Supreme Court to use the word appellee, if that's what they want me to do, they're the ones deciding the case, so I'm going to do it. And I think that's really the principle when you talk about your boss. If your boss wants it that way, that's the way you do it until that person's not your boss anymore.
And I think that's good advice. You know, as a younger partner, it can be difficult to balance that expectation. But I think if I could just add to Chad's to answer there is, I think even working within the framework of following the guidance from your supervisor or your partner, there are a lot of ways that you can hone your craft and continue to develop things and work within that system, so that when you are a young partner or a more senior partner and you're starting to work for your clients as opposed to working for someone else's clients, you're in the position to jump and practice maybe the way that you want to. It's kind of a waiting game where you continue to develop your craft, hone your abilities, and never stop evolving. So that when you are ready to take that step, you can take that step and practice how you want to. But, well, this has been a fantastic panel. I really appreciate both of your time, Chad and Kevin. I'm honored to have been on this panel and able to have this conversation with you guys. But unfortunately, I think we're out of time for today. Thank you again.
Thank you very much.
Thanks, guys.